Good morning. I'm Hallie Zobel with Private Corporate Counsel. I can be reached at hzobel@pcc.law or phone number 407-647-7887. Give me a call sometime. I'm a Florida probate attorney. Today we're going to be talking about how to transfer car title upon a death. I have a story to tell you that when my own father passed away, I took my nephew to the Department of Motor Vehicles, was able to get a number and a virtual line, and then showed up for still a long wait. But he and I were able to both sign the paperwork after my father passed, and then the car was transferred to him. What we did have to do, though, the family had to agree that my nephew was going to receive the car from my father's estate, and it would be considered a share of my sibling, as nothing was specified in the will regarding this car disposition. So I've got some tips for you today on how to transfer a car after death. It really comes about with two situations. One, there might not be a probate to probate. Perhaps everything is in the estate is in a trust, or perhaps there's just no assets. But the first way to transfer would be if there is a will and someone's been appointed executor. Florida uses the term personal representative, but you may be more familiar with the term executor. So in that situation, the personal representative, after he's appointed, would go down to the tag office, like I did with my nephew, and fill out a title application form. They'd have to provide a certified copy of the will. Certified just means that the clerk of the county has certified the will as an authentic copy. And they'd have to sign an affidavit that the estate is solvent. That means there's money in the estate. And provide the original title certificate from the car, of course. So the state of Florida, is going to have some other requirements. You got to show proof of insurance. We require insurance driving in Florida. They're going to require the odometer reading and any type of loan agreement if there was a loan on the car. So once you provide those things to the clerk at the Department of Motor Vehicles, you can get the you can get the car transferred. Maybe it's not a car, maybe it's a motorcycle, maybe it's a boat. Now, what happens in a second scenario if there's no will? That means intestate. The person passed with no will. Once again, we look to the Florida law. You're going to have the same procedure as with a will, but the affidavit the person signs down at the tag office is going to state that the estate is not indebted. That just means the deceased didn't owe anyone any money. There's no creditors, and the survivors have agreed among themselves who the owner's going to be. These laws can be real tricky, and you want to make sure you don't swear to something that is not true. If the Internal Revenue Service is owed money, I'd be careful about proceeding in this fashion. It's always best to speak to a qualified attorney who knows about these issues prior to taking any action. I had a lady call up a few weeks ago and explain that she had transferred her sister's car after her sister passed to herself. I'm not quite sure how she was able to do that because there were other heirs. But as it turned out, the IRS was owed money in her sister's estate, and I explained she needed to get another type of an attorney because she may be facing some type of claim by the IRS on her. So always speak to a qualified attorney, and it's best to speak to them before you act, before doing an act, so you know what all your options are. Thank you for listening, and remember, I'm the attorney at Private Corporate Counsel. I can be reached at hzobel@pcc.law or telephone number 407 647-7887. This is Law Moment with Hallie Zobel.